Here we're going to talk about one specific statutory limitation on that at-will employment doctrine. The general rule, again, in the employment context is that you can be let go for any reason, even if it's not a good one. But we have many federal statutes that deal with specific situations that further limit when and how an employer can go about terminating you or otherwise taking adverse employment action against the employee. This is called the Family and Medical Leave Act, and as you can imagine, it deals with the situation where someone needs to take leave for medical reasons or because of medical reasons related to some immediate family members. Now, this is unpaid medical leave that's guaranteed by the federal government. There are many other countries that guarantee in comparative statutes paid medical leave, so you get to take time off work for those medical situations, and you're guaranteed to keep getting your paycheck while you're on leave. But in America, we don't have that right now, and you hear it come up in political discourse a lot, especially in campaigns, whether it's time for us to have a paid act. But right now, it's unpaid leave. So the guarantee is not so much that you're going to keep getting paid while you're on medical leave, but that you can come back to that job and come back and start working again and then get paid. Now, private employers can provide their own plan if they want. This is just the federal minimum that people have to live up to. And then I'm not an expert on what every state does. I'm sure some state governments have maybe their own medical leave plans that might add more protections than this one. But this, again, is just the the minimum that we're mandated to do by the federal government here. Now, it doesn't apply to all employers. For private employers, it only applies to employers who have 50 or more employees. So this isn't going to apply to, a job where like a mom and pop store that has, 11 employees. But again, there could be some issues in the particular state. I'm sure California is a lot different than we are here in South Carolina, so you need to also be aware of that in addition to what we're going to talk about here. But this applies to employers with 50 or more employees, and then it applies to all governmental entities. So if you're a government employee. Now, what it provides for is up to 12 weeks, again, of unpaid leave per year for an employee's own serious illness. That's when you're sick as the employee, and you see a breakdown of that, of what's considered a serious illness. And then it also covers, interestingly, childbirth, and then especially adoption. I think that's interesting. And then to care for a seriously ill child, a spouse or parent. So it deals basically with serious illnesses of you and your immediate family, and then childbirth and adoption. And you can see the definition there of a serious illness. I'm not going to spend a whole lot of time on that, but you can see it there for yourself. Your health care benefits, whichever ones you have, if you have any, have to remain in place for obvious reasons while you're on taking your medical leave, even to take care of yourself or for a child or spouse or parent. And then when you return to work, what it really guarantees is that you'll be put back in the same position you were when you left, and that they won't eradicate your position. It doesn't necessarily have to be the exact same job, but it has to be something comparable. So you can't come back to a job where all of a sudden you have a lot less responsibility and you're making less money. So they might have to shift things around a bit, but you're guaranteed to basically have, the job you had when you left, essentially. Now, it doesn't apply to all employees either. You have to have worked there for a certain number of hours, or at least a year, before it'll kick in. And you can see why this could be important. You don't want somebody to have a scheduled medical procedure, for instance, that's going to keep them out of work. And some people might disagree with this, maybe think it should kick in sooner. But for the employers, it's trying to protect an employer from hiring somebody and then they immediately take advantage of this medical leave, and they can take off and take care of this before they've even had a chance to learn the job. Maybe we should extend it so that you don't have to be there as long. But that's the way it is right now. And it's actually one of the things the coronavirus emergency laws has addressed. It's one of them. I think it's the one that pertains to taking care of a child, has changed that to, I think, 30 days. You only have to be there 30 days. It may have gotten rid of it entirely, so don't quote me on that. Look it up for yourself to make sure. But it's changed it drastically from having to be there for at least a year or 1,250 hours in the last year. So it's either a full year or you can do it by the hours. So that's when it kicks in. So you have to work there for a little while before it kicks in. And then it also doesn't apply to what are called key employees, which are the highest earners in the business. And well, you can see a quote from the right there, who's, if they were to leave the job on, for serious medical concerns, if they're not being there would cause substantial and grievous economic injury to the operations of the employer. So these are people that basically the law is contemplating can't be replaced, and we can't expect the employer to just move on while they're out for weeks or months, for up to 12 weeks at a time, which amounts to a few months. These are people that just can't, their work maybe can't just be replaced by somebody else. So a lot of people, you have noticed that they're going to be out for a while, and you can maybe have just about anyone there cover their shifts, and it's not a big deal. But the key employees exception is, again, for people whose job really just can't be done by anyone else. And if they can demonstrate that their absence causes substantial and grievous economic injury. So that's kind of a high standard. It's more than just showing that they're a key employee. You also have to show this economic injury by their absence. So it's going to cover most people most employees if they've been there for the requisite amount of time. And that's basically the Family Medical Leave Act. Again, remember that there is some emergency laws that have altered and extended this a little bit for the coronavirus situation. So if you're in that situation, make sure that you're aware of those new laws that are going to be here on a temporary basis.